We will now consider Bill C-304 under private members' business.
Consideration and second reading of Bill C-304, an act to amend the Canadian Human Rights Act protecting freedom, standing in the name of Mr. Storseth.
Mr. Storseth, seconded by Mr. Rathberger, moves that Bill C-304, an act to amend the Canadian Human Rights Act protecting freedom, be now read a second time and referred to the Standing Committee on Justice and Human Rights. The honourable member for Westlock St. Paul's. I wanted to
Thank you, Madam Speaker, and I'd like to congratulate my fellow colleague from Burlington for an excellent 2.5 minutes. It is an honour to be here, Madam Speaker, to present a bill that is very near and dear to my heart, to this House of Commons. And I would like to begin by first thanking the people of Westlock St. Paul for the trust that they have placed in me for a third consecutive election to bring forward their concerns in this august chamber. I would also like to thank my friends and family for their support and dedication over the last 6 years, my parents for their willingness to always pitch in and help, my children, Aiden and Easton, for their endless patience and love, and most importantly, my wife Amal, who is my best friend and the rock that anchors our family. Without their love and support, this job would be so much more difficult. I would also like to thank my colleagues who have stepped forward, both past and present, to support Bill C-304, Protecting Freedom. While my bill will have some technical amendments at the committee stage, it will help to protect and enhance our most fundamental freedoms, and that is the freedom of expression and speech. As George Washington said, if the freedom of speech is taken away, then dumb and silent we may be led, like sheep to the slaughter. Truly, without the freedom of speech, what is the use of any other freedoms, such as the freedom of assembly or the freedom of religion? The freedom of speech is the bedrock that all other freedoms are built on. This, along with the concept of natural justice and due process, are woven into the fabric of our great country over the last 144 years. As we were reminded only a few short days ago during Remembrance Day, tens of thousands of Canadians have given their lives to protect these fundamental freedoms. And that is why I stand before you today, Mr. Speaker. Section 13 of the Canadian Human Rights Act eats away at this fundamental freedom. Most people are shocked when I explain to them that in Canada, right here in our own country, you can be investigated under a Section 13 complaint for having likely exposed a person or persons to hatred or contempt by reason of the fact that that person or those persons are identifiable on the basis of a prohibited ground of discrimination. The key word here is likely to have exposed. I think we can all agree that this is a very subjective and unnecessarily vague definition, not one of the narrowly defined legal definitions that would be far more appropriate for this clause. And this is where Section 13 truly fails to make a distinction between real hate speech and what I often term as hurt speech, or speech that is simply offensive. This means if you have offended somebody and are investigated under Section 13 of the Canadian Human Rights Act, intent is not a defense. Truth is no longer a defense. You no longer have the right to due process, the right to a speedy trial, or even the right to a lawyer to defend you. In fact, 90% of the human rights investigations under the Canadian Human Rights Act on Section 13, the defendants don't even have legal advice because they simply cannot afford it. When the people of Westlock St. Paul hear about this, they're shocked. This is simply not the Canadian way. Facing intense criticism in 2008, the Canadian Human Rights Commission handpicked Professor Richard Moon to provide an evaluation of Section 13 of the Canadian Human Rights Act. In quoting Dr. Moon on page 31 of his report, in regards to the repeal of Section 13 and reliance on the Criminal Code hate speech provisions, and I quote, "The principal recommendation of this report is that Section 13 be repealed so that the censorship of Internet hate speech is dealt with exclusively by criminal law." This recommendation was dismissed by the Canadian Human Rights Commission, who in turn provided a list of recommended amendments to Parliament in 2009, none of which have been implemented to date. Thus, Even the Canadian Human Rights Commission has admitted with their own recommended amendments that there are serious flaws within Section 13. Section 13 of the Canadian Human Rights Act has been a contentious topic for a number of years now, and it has been widely acknowledged that it does, in fact, impede upon Section 2B of the Charter of Rights and Freedoms, which states that everyone has the fundamental freedom to the freedom of thought, belief, opinion, and expression, including freedom of the press and other media communication. This confliction between Section 13 of the Canadian Human Rights Act and Section 2B of the Charter has been reaffirmed by the Canadian Human Rights Own Tribunal, which found that Section 13 was, in fact, unconstitutional in September of 2009. A common argument in favor of Section 13's right to censorship and its constitutionality is the overruling powers provided by Section 1 of the Charter of Rights and Freedoms, an argument I am sure that the opponents of my bill will bring forward. Section 1 does provide a provision within the Charter to ensure that all guaranteed rights and freedoms are subject to reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. There are but a few issues with applying this provision to Section 13. Most importantly, Section 13 lacks the ability to demonstrably justify the limits that it imposes on our society. It does not define the difference between hate speech and hurt feelings and offensive speech. Secondly, how can a loosely written, highly subjective, vague law such as Section 13 override the Charter of Rights and Freedoms in a free and truly democratic society? Section 13, which is intended to protect people from extreme acts of discrimination in regards to hate messages, as previously was defined by the Supreme Court of Canada, it has instead been used to address differing values or opinions and impedes upon one of the most basic civil liberties that we hold dear to our hearts, the freedom of expression. Mr. Speaker, I believe the true issue of debate here is at what point and to what extent is censorship justified in Canada today. As I debate this question, I think of my good friend and constituent, Bob Herrick from Wissett, Alberta. Bob is a very bright and very successful man who, like many in his generation, have had a tremendous life and tremendous experiences to go along with it. He holds some very diverse opinions. No matter what topic you are discussing, from hunting to political philosophy, Bob loves to test your convictions and boundaries. Often while trying to challenge your own assertions, Bob will go well beyond political correctness and often be even a little bit offensive. It is in his ability and freedom to push the limits of political correctness, however, that truly tests the merit of your own beliefs. In society, when you lose the ability to test limits through freedom of expression, you also lose the ability to grow and adapt as a country peacefully. It is through freedom of speech and expression that we change governments here in Canada, not through riots and revolts. This is one of the unique factors that sets us apart from many countries in the world. Women such as Nellie McClung gained the right to vote by testing societal norms through expression and freedom of speech. Layer by layer, brick by brick, our country has grown and successfully developed by utilizing and enhancing our fundamental freedoms. And so it is today that we must continue to fight the tyrannical nature of the bureaucracy to censor free speech, to tell us what boundaries should be placed on our society and what rights that we have as individuals. So how do we ensure individual freedom of speech while at the same time protecting people and identifiable groups from direct harm if we repeal Section 13 of the Canadian Human Rights Act, one might ask? The answer to this question is that we must direct these complaints to a fair, open, and transparent judicial system, one that has been tested for hundreds of years within our own country. With the repealing of Section 13, individuals will still have recourse through both the civil and criminal justice systems. Sections 318 to 320 of the Criminal Code provide protection for identifiable groups where public communications invite hatred or harm against them. The continued use of the Criminal Code to address hate messaging will ensure that all individuals are protected from threatening discriminatory acts while preserving the fundamental to freedom of expression in our country. An integral component of the Criminal Code is the need for the Attorney General to approve a claim. This prevents frivolous claims or claims where an expression merely offended another individual. It is also important to note that the Criminal Code provides basic provisions to the defendant that are not available through the Canadian Human Rights Act. I repeat, the provisions I'm about to talk about are not actually available to Canadians under the Canadian Human Rights Act. Provisions such as allowable defences, the right to face your accuser, the right for the defendant to recover costs if a claim is dismissed, and the right to an open, fair and transparent trial. These are just a few of the basic liberties available under the Criminal Code. This is a system which has been tried and tested, a system with checks and balances, a system in which our society has entrusted their fundamental freedoms with and has seen fit to enforce the rule of law in our country. John Fitzgerald Kennedy described it best when he said, "We are not afraid to entrust the American people with unpleasant facts, foreign ideas, alien philosophies, and competitive values. For a nation that is afraid to let its people judge the truth and falsehood in an open market is a nation that is afraid of its people."
Hear, hear.
Mr. Speaker, freedom of speech and the use of censorship on that freedom is not a matter to be taken lightly and should be entered into with the utmost of caution. That is why I personally find it highly alarming to hear a Canadian human rights investigator, someone entrusted as a gatekeeper of our fundamental freedoms, disvalue freedom of speech in Canada, claiming it merely to be an American concept. This is precisely the mentality that Section 13 of the Canadian Human Rights Act is harboring, and just one more example of how unfit Section 13 and the Commission are to handle any level of power to censor speech in our country. Freedom of speech is just as valued here in Canada. In fact, it is the only real tool that free and democratic societies like our own have to fight bigotry and ignorance. Any imposed censorship on this freedom must be taken very seriously and not met with casual disregard. The solution here is not to fiddle with a broken, repetitive, and unnecessary system. I believe the solution is to use the laws we already have and provide authorities with the tools and support necessary to properly and carefully enforce these laws. The government has already announced its support to enhance the ability of the Criminal Code to better address hate messaging. This step, as well as the one-year implementation period in my bill, will ensure the successful transition to a system in which true democracy and freedom of speech can thrive. It is time we retract the power entrusted to the quasi-judicial bureaucratic system to deal with hate messaging and prevent the future abuse of this system. Freedom of speech is the bedrock upon which all other freedoms are built, and therefore is too precious to leave under the thumb of censorship imposed by this system. Without freedom of speech, what good are our other freedoms, you may ask? Finally, Madam Speaker, I would like to encourage all of my colleagues to stand up and protect our fundamental freedoms, the same freedoms which we have asked our soldiers to put their lives on line to protect time and time again. This truly is not an issue of blue versus orange versus red. This is an issue of freedom, transparency, and balance for all Canadians. Thank you, and God bless.
Hear, hear.
Questions and comments? The Honourable Member for Gatineau.
Merci, Madame la Présidente. J'aimerais que...
Thank you, Madam Speaker. I'd like the colleagues for opposite be so as respectful for freedom of speech as they are to freedom for debate. They want freedom for speech, but they don't like debate because we're constantly being muzzled. So that raises some questions with respect to their logic and to the merit of some conservative positions. Now, I have a question, and I'd like to put the question to the member responsible for Bill C-304. I'm wondering if he's aware of the various burdens of proof that exist under the Charter, under the Criminal Code. Does he not think that by removing recourse under Section 13 of the Charter, that the burden will be increased and it will be very difficult for the court as regards hate propaganda?
Thank you very much, Madam Speaker, and I would like to thank my honourable colleague for the respectful question. In fact, at the beginning of her question, she talks about the ability to debate a bill. I would like to remind her this is a private member's bill, not a government bill, and it was actually the NDP that filibustered even me having this ability to speak last Wednesday. That being said, I think it is very important that we have these debates, that Parliament isn't scared to have an open, honest, respectful debate on the important issues of our country. That is what engages the citizenry of our country. I was meeting with My Canada this week, who is a great youth group in our country with over 5,000 participants, and they strongly endorse my bill, and they endorse also the ability to engage in the freedom of speech in this country and change the fundamental values of our country to mold it to the way that they see it, to the way the youth see it moving forward in our country. And that is very important, because it is very true, Madam Speaker, that the only real way to fight ignorance and bigotry in our country is by enhancing the fundamental freedoms like freedom of speech, so that we can be a true and democratic society that continues to grow, thrive, and foster.
Questions and comments? The Honourable Minister of Citizenship and Immigration.
Thank you, Madam Speaker, and I would like to commend my colleague, the member for Westlock St. Paul, for this frankly courageous and principled initiative, which I think many of us in this House have known for some time has been a necessary step to protect our inheritance of freedom of speech, which is a fundamental principle of our constitutional inheritance of our country's political values. I wonder if the member could comment on some of the groups that have long called for repeal of this much abused section of the Human Rights Act. I understand, amongst others, that the Canadian Civil Liberties Association, the Canadian Association of Journalists, the Muslim Canadian Congress, organizations that span the entire political spectrum, from the Toronto Star to the National Post, have all called for the repeal of this legislation. Could the member please comment on the breadth of support, the consensus that seems to exist for this bill?
Good question.
Full member for Westlock St. Paul.
Thank you very much, Madam Speaker, and I'd like to thank the Honourable Minister for not only his gracious words, but his dedication towards the freedom of speech and the freedom of religion and assembly that he has fought for his entire political career. He is absolutely correct that this bill, C-304, protecting freedom, is not about left versus right. This has support from the Canadian Muslim Congress, from civil libertarian groups. This has support of journalists across the political spectrum. The only thing that we're lacking today is support throughout the House of Commons. I would like to see all members of Parliament set their partisanship aside, take an issue like this and actually vote on it with the principles, with your own principles, rather than what the party whip may put on you. Because at the end of the day, it is debates like this that we have to be able to have in a respectful fashion. But Canadians also expect us to vote our conscience when it comes to these types of issues. And that is why I think it is so very much important that we keep this debate respectful, but also we engage in an open, honest, transparent debate. Thank you.
Reprise du débat.
Resuming debate. The Honourable Member for Gatineau. Thank you, Madam Speaker. I'm not convinced by the way the colleague opposite answered my question. However, I am still open to debate in this House, to debate, I reiterate, to free debate, so that people who have a desire to speak to an issue can do so. There are many important issues before this House, Madam Speaker, and all of the issues have been quickly rammed through by the government. Now, I understand that this is a private member's bill put forth by a colleague who's not a minister or a parliamentary secretary. However, there is a problem in this House where people are being prevented from getting involved in debate. Now, I just got information about votes tomorrow to limit debate at third reading. We come to the House, we debate issues, bills are presented, they're introduced, and many of them are very, very long, contain a number of aspects, but as soon as there's any objection to them, time allocation is imposed at second reading. We're told, oh, no, you'll have an opportunity to discuss the issue at committee during clause by clause, and I in fact, have come from one where we've been doing clause by clause consideration, and we're facing time allocation there as well. And it's a bill that will make fundamental changes to Canadian society. A member opposite is now moving ahead with Bill C-304, and it focuses on freedom of expression, but on the government side, I really have a difficult time believing in it and believing in the merit behind it. For people listening to us and who are wondering what Bill C-304 is, it's an amendment. It would involve eliminating Section 13 of the Canadian Charter of Human Rights. Section 13 is a provision which disallows hate messages. And this section was deemed consistent by the Supreme Court of Canada. A commission. It's something that the Supreme Court in the Taylor decision, that Section 13 was consistent. It was also necessary in a free and democratic society. Now, don't forget that the Charter of Rights and Freedoms contains limits. Now, rights turn into limits. For some, they are rights. For others, they are limits. And the government is trying to make people afraid here. That's another one of their specialties. If the average citizen is before the courts on freedom of speech, well, most time it's been, in fact, there haven't been that many issues. It's not as if everyone's running to the Human Rights Commission in order to take recourse under Section 13, in order to complain that someone has made hateful remarks. And I reiterate, the legislation reiterates what hate speech is all about. It's not about saying, I don't like you, I don't like the way you look. But if I receive a tweet, Madam Speaker, and someone asks me, as a member for Gatineau, what are you going to do on an issue where your former leader is associated with the Gestapo compared to Hitler on an internet site called www. And it's so disgusting I don't want to advertise it. It's something terribly disgusting, but it's Park Avenue Gazette. And when they attach symbols from the Second World War and associate it with people who are human beings, imagine how those people feel when they see those types of situations or websites. Now, we're always reminded by the people opposite, yes, but the criminal code does contain measures to deal with that. Well, my reply to the member for Westlock St. Paul, well, in fact, I put a question to him, but he didn't answer it. If he relies uniquely and solely on the criminal code, there's a burden of proof. It's very different. So recourse isn't new. Recourse under the criminal code at the commission, where there are summary offenses under the criminal code. There are also civil measures of civil recourse and the charter, and this is the case here. So there are sections in the criminal code which contain different types of proof. It can be the proof beyond all a reasonable doubt, etc. But under the charter, the burden of proof is different. Now, what we're not being told, and what we've noted here with respect to freedom of expression, is freedom of expression doesn't give me the right to, for any reason, denigrate someone, to tell them they don't deserve to live, all those kinds of remarks. Would that merit or warrant a recourse under the criminal code? No. Crown prosecutors are already, in fact, very busy. They'll be even busier with the government's Bill C-10. So I can't see how they could have time to take a look at issues like this. And it could be interpreted differently, of course, but the Human Rights Commission is a specialized organization which had an opportunity to look at a specific case, and before it went forward to a court, they determined whether or not a complaint was warranted under the Charter. But nobody wants that. Why? Because many of the government's friends, and when I say a number of them, I've just exaggerated, but some of the government's friends, journalists from the West, have expressed certain views and have complained for many years that Section 13 prevents them from expressing all of the things they want to. Now, we live in Canada here, and in Canada, I've always believed that it was our duty to be respectful. We can disagree, but we're not authorized to denigrate another person, and this is what we're talking about here. We're talking about freedom of expression, but making someone feel as if they're worthless, and no. Now, I can't believe that the Conservatives, Madam Speaker, want that type of situation that affects francophones, people who believe in bilingualism, people who believe that this country exists thanks to the two founding peoples and the First Nations, that we should simply just eliminate it and allow anyone to say whatever they want. It's as if you were to say, well, oh, it doesn't matter, I have freedom of expression. Come on. I agree that freedom of expression is important, and I hope that people will rise to speak to this issue and to remind the House what the Supreme Court said in the Taylor case, and it covers the importance of Section 13. Justice Dixon, who was an excellent writer, wrote on behalf of the Supreme Court, and I'll wrap up with this because I would have a lot of other things to say, but because of the limited time I have, I'll only have an opportunity to say a few words. But this issue regarding hate speech runs counter to, well, in fact, the prejudice and whatnot has been recognized by the Hate Propaganda Committee, the Cohen Committee, and this was studied in 1970. The Cohen Committee pointed out that individuals subjected to race-based or religious-based hate will experience psychological distress. This will result in anger, loss of self-esteem, etc. because of what distinguishes them from others. This will hinder a person's ability to flourish, and this refers back to Section 2. The committee also stated that hate propaganda would even convince viewers subtly that certain religious groups are inferior to others. Now, I could continue reading these quotes and whatnot, Madam Speaker. Inaudible.
Resuming debate.
Debate, the Honourable Member for Mount Royal.
Thank you, Madam Speaker. The notion implied in the private member's bill, which seeks to repeal Section 13 of the Canadian Human Rights Act on the ground that the sanctioning of hate speech dilutes and diminishes freedom of expression, which I've said elsewhere is the lifeblood of democracy, which I agree with the honourable member that this is a bedrock principle, and I've always so affirmed. But the premise underlying the bill is, while well-intentioned, misinformed and misleading. It seems to suggest that freedom of speech is an absolute right, that it does not admit of any limitation, ignoring that all free and democratic societies, including the United States, the home of the most robust protection of freedom of speech under the First Amendment doctrine, and where my old mentor and professor, the then Dean of Yale Law School, Abraham Goldstein, said that freedom of speech is not an absolute right, though people continue to persist that it is. So all free and democratic societies, including the U.S., have recognized certain limitations on freedom of expression in the interest of protecting certain fundamental human values. For example, prohibitions against perjury to protect the right to a fair trial, prohibitions against treasonable speech to protect national security, prohibitions against pornography to protect the human dignity of women and children, prohibitions respecting libelous and defamatory speech to protect privacy and reputation, prohibitions against misleading advertising to protect consumers, and I can go on, Madam Speaker. Simply put, the provisions against hate speech partake in this genre of limitations to protect the rights of individuals and minorities against group vilifying speech, to protect against those discriminatory hate practices that reduce the standing and status of individuals and groups in society, thereby, in fact, constituting an inequality concern. And indeed, and this may surprise the member moving the motion, to protect the very values underlying free speech itself. As the Supreme Court of Canada put it in the Keekstra, Smith and Andrews and Taylor cases, and Madam Speaker, may I make full disclosure, I appeared as counsel in these cases and did so as a proponent of freedom of expression, as one who has advocated for this bedrock principle before the courts and have written extensively upon it. But as the court put it, the Supreme Court, and I cite, hate speech itself constitutes an assault on the very values that underlie freedom of expression. That this promotive hate speech actually constitutes an assault on that bedrock principle of freedom of expression. Moreover, said the court, and this is of particular relevance respecting any proposal to repeal Section 13, and I made this point before the Supreme Court of Canada in the trilogy of cases I referenced earlier. Hate speech is an equality issue as well as a free speech issue. That the promotion of hatred and contempt against an identifiable group results in prejudicial harm to the individual and group targets of that hate speech. That this harms-based rationale, as the Supreme Court characterized it, supports the sanctioning of hate propaganda as protective of equality. As the court put it, and I cite, the concern resulting from racist hate-mongering is not simply the product of its offensiveness, but from the very real harm it causes, as a member of Gatineau illustrated in her remarks this evening. Moreover, said the court, referencing international law, these anti-hate provisions were themselves implemented, enacted as a domestic implementation of our undertakings under international law, under international treaty provisions respecting combating hate speech. And again, I cite the Supreme Court, quote, the protection provided to freedom of expression in international law does not extend to cover communications that advocate racial or religious hatred. Similarly, the court invoked Section 27 of the Canadian Charter of Rights and Freedom to argue that hate messaging as well constitute an assault on our multicultural heritage and normative principle. Accordingly, Madam Speaker, I'm pleased to participate in this debate on Bill C-304, the bill that would repeal Section 13 of the Canadian Human Rights Act, and whose effect would be to prevent claims from being brought before human rights commissions, such claims as might protect against group vilifying speech while upholding the freedom of speech and the values that underlie it as well. Madam Speaker, I understand that the Governor's concerns with Section 13, but the response should be not to repeal the legislation on the alleged ground that it constitutes an assault on freedom of expression, principle which, as I said, I and many members in this House are long-standing advocates. But while ignoring the countervailing protective need to protect against group vilifying speech. Simply put, the solution is not to repeal the legislation whose constitutional validity has been upheld by the Supreme Court, but to address the concerns and to offer proposals to modify the regime that is now in place. I would urge the government to consider the possible reforms to address any valid concerns, which I will now outline in my subsequent remarks as preferable to outright appeal. As members may be aware, this very section of the Canadian Human Rights Act is now under review by the Supreme Court of Canada. This debate, therefore, Madam Speaker, if I may say parenthetically, is somewhat itself premature, as we should wait for guidance from this nation's highest court on the scope and ambit of freedom of expression before entering into this debate. That said, the Supreme Court has already provided much guidance in this area, as I have outlined, and has ruled that as a matter of constitutional law, freedom of expression constitutes hate speech constitutes an assault on the very underlying principles respecting freedom of expression, the search for truth, the protection of individual autonomy, democratic debate and stability. And while protecting vulnerable groups from hate messages, it promotes and protects the fundamental principle of equality. And that even if it should be found to prima facie infringe on freedom of speech, as former Chief Justice Dixon put it in these cases, the infringement may be characterized as a reasonable limit prescribed by law, demonstrably justified in a free and democratic society. And it is in that context and spirit that I offer the following recommendations. First, the criminal code to which reference has been made with regard to its hate speech provisions has a built-in filtering mechanism through the requirement of the consent of the Attorney General for launching a prosecution. I would recommend a similar filtering provision with regard to the Canadian Human Rights Act. Second, procedural protection could be put in place to limit complainants to one jurisdiction at a time, rather than having, as we now do, a barrage of federal and provincial complaints that are instituted against the same individual or group, thereby serving as what has been called a strategic lawsuit against public participation, SLAP in its shorthand, that can understandably serve to chill speech. Third, we could add a statutory definition of hatred and contempt in accordance with the definitions as offered by the Supreme Court of Canada in the Taylor case itself. Four, we can include a provision under Section 41 to allow for the early dismissal of Section 13 complaints when messages do not meet the narrow definition of hatred or contempt. Fifth, we could repeal the provision that allows for the assessment of a punitive sanction. Sixth, Madam Speaker, we could implement better procedural safeguards in terms of the trial process and evidentiary standards. And finally, Madam Speaker, other reforms the government might consider include allowing commissions to award costs, thereby dissuading persons from bringing forth frivolous matters. As well, the Commission could also remove the possibility of an anonymous submission such that the right to face one's accuser is better respected. In closing, Madam Speaker, the debate we should be having tonight, if we are to debate this in advance of the Supreme Court decision which we should be awaiting. But the debate should nonetheless be, given the Supreme Court decisions that we do have, how we might reform and structure human rights commissions to both protect freedom of expression while protecting vulnerable individuals and minorities from hate and group vilifying speech, rather than committing ourselves to abolishing the entire regime, because it has produced results which can be addressed through positive reforms, as I have indicated this evening, which will address the members' concerns. So I would urge the government to rethink its approach and consider some of the reforms I've outlined in my remarks that are intended both to protect the bedrock principle of freedom of expression and the values that underlie it, as well as to protect individuals and groups and vulnerable minorities from this group vilifying speech. Thank you, Madam Speaker.
Resuming debate, the honourable member for Ancaster, Dundas, Flamborough and Westdale.
Thank you very much, Madam Speaker. It's a great privilege for me to stand in this House today and speak on Bill C-304, an act to amend the Canadian Human Rights Act protecting freedom. I fully support this bill as it protects one of our most important rights as Canadians, that being the freedom of speech. In my years on our House of Commons Subcommittee on International Human Rights, we've often spoke out against repressive regimes around the world who trample the rights of their own citizens in the most severe ways. And yet, the fundamental right to freedom of speech is threatened here at home. I'm pleased that this bill proposed by the member from Westlock St. Paul seeks to remedy just that. Madam Speaker, as you've heard from my colleague before me, freedom of speech is a fundamental right that provides the basis for all other rights to thrive and succeed. Without free speech, citizens cannot assemble publicly to peacefully demonstrate their opposition to government policies, an act fundamental to our democracy. Taken further, Madam Speaker, one could say that without freedom of speech, we could not worship God, we could not practice our faith, we could not join unions or speak out during elections or other moments of democratic participation. These are some of the very criticisms we have of totalitarian regimes. And we need only think of the recent events in Egypt and Libya and the ongoing Arab Spring to understand that, in the end, freedom of speech must always prevail. Madam Speaker, Section 13 of the Canadian Human Rights Act is a direct attack on the freedom of speech that is guaranteed to us under the Charter of Rights and Freedoms. Section 13 of the Canadian Human Rights Act allows the Canadian Human Rights Commission to prosecute anyone alleged to have said or written something likely to expose a person or persons to hatred or contempt, whether there's a living, breathing victim or not. In essence, this is like charging someone for the likelihood of breaking a law, but not yet breaking the law. Madam Speaker, for those that have seen the 2002 Hollywood blockbuster Minority Report, some might say it's starting to go down that path. The movie stars, amongst others, are three psychics called precogs. It depicts an eerie fictional future where the pre-crime department, along with supercomputers, labels criminals before they even commit a crime. However, the system ignores its own flaws or minority reports, in the end labeling innocent people and marginalizing a whole subclass who fall outside of the societal norms as directed from the top. Madam Speaker, while the movie is fictional and takes the point to the nth degree, what's true in reality today is that Section 13 is inconsistent with our democracy and our criminal code, which abides by the principle of charging someone after they commit a crime, not before. Madam Speaker, if that's the principle that our criminal code is governed by, why isn't this the principle also central in the Human Rights Act? That is what this bill from the member for Westlock St. Paul is aiming to do, bringing the principle of our tried and tested justice system to human rights, and consequently to the Canadian Human Rights Commission. Madam Speaker, for a clear example of the Section 13 hindering free speech here in Canada, we do not have to look far. For example, as the member from Westlock St. Paul previously alluded to, the Canadian Human Rights Commission investigator, Mr. Dean Stacey, was asked what value he gave freedom of speech in his investigations. To me, it's shocking that Mr. Stacey replied, "Freedom of speech is an American concept, so I don't give it any value. It's not my job to give value to an American concept." Madam Speaker, I take umbrage with that. Freedom of speech is very much a Canadian concept, one that we should be very proud of. And most importantly, in this second week after Remembrance Day, let us never forget the ultimate sacrifice made by thousands of Canadians from the trenches of Europe to the hills of Afghanistan so that we can enjoy so many freedoms, not the least of which is the freedom of speech, but also so millions suffering in Europe during the 2 world wars and in other conflicts since could also be free. Madam Speaker, the list of those affected and stifled by Section 13 is long and encompassing. Every journalist, writer, webmaster, blogger, publisher, politician, and private citizen in Canada can be subject of a human rights complaint for expressing an opinion or telling the truth on any given issue. With the ambiguity of Section 13, it is virtually impossible for any person to determine if they might be in violation of Section 13 or not. This, in a nutshell, creates a culture of forced censorship and punishment for those who dare speak their mind. This is wrong and cannot be justified in a free society that Canada credits itself to be. This is also unimaginable in the digital world that has reshaped how our society communicates, Madam Speaker. Is it possible that the 140 characters of a tweet could be misconstrued? Is it possible that a blog could be unduly censored? Bill C-304 can and will fix this, and that is why I'm standing in this House today to support it. Madam Speaker, there will be some who say that getting rid of Section 13 of the Human Rights Act will open the floodgates to hate speech and the like. As the member for West Block St. Paul noted, Sections 318 through 320.1 of the Criminal Code already prohibit hate propaganda, including any written, sign, or visible representation that advocates or promotes genocide. There's nothing more vile in the world than hate propaganda. I have worked over the last few years to draw attention and take action on the rising threat of anti-Semitism for this very reason, Madam Speaker. Quite frankly, will some people say or continue to say things that are nasty, things that everyone in this House would find offensive? Certainly. However, so long as it's not hate propaganda, should we not defend their right to say it, so that we are preserving the right of all people to speak their minds, and in doing so, thereby preserving our right to speak out against unsavory speech? In closing, Madam Speaker, may I iterate the importance of free speech here in Canada. Our country was built on free speech. Our veterans have fought for free speech, and let us together as a House ensure free speech is not hindered the way Section 13 does today. Thank you very much, Madam Speaker, and God bless Canada.
Reprise du débat.
Resuming debate, the honourable member for Terrebonne-Blainville. Thank you, Madam Speaker. I'm going to begin by saying that the Conservatives always talk about how important it is for them to make our communities safer, but they seem to want to weaken the restrictions against hate crimes, and that appears contradictory to me. Madam Speaker, we all know that this Conservative government has a love affair with the right-wing Americans under George Bush. In fact, it was the Republicans who supported mandatory minimum sentences and the elimination of pardon applications in the 1980s, and this caused the prison population to skyrocket without necessarily improving the safety of its citizens. It was the same Republicans who always take the First Amendment of the Constitution, that is unconditional freedom of expression. Unfortunately, there are extremist groups of all kinds who use it to convey homophobic, racist, Islamophobic, and anti-Semitic messaging while protecting themselves with the first. In fact, the American standard goes against some international conventions that condemn hate speech. Madam Speaker, the Conservatives like to talk about victims and show compassion for their situation, as we should all do. However, in this case, their ideology is blinding them completely. They're forgetting people who are already marginalized, such as racial minorities and religious minorities, and the gay, lesbian, and transsexual communities. They forget the dramatic effect that hate speech can have on someone who is already marginalized. They're forgetting the suicide epidemic among gay, lesbian, and transsexual teenagers in the United States and Canada, and they're forgetting the attacks against visible minorities. Madam Speaker, the expression of hate and intolerance are the main causes of these tragedies, and that is why we must at all cost maintain the protections against these forms of harmful expression. I heard the member who is no longer now right now. Oh, I apologize. I know I'm not allowed to say who's in the House and who's not. I apologize. I withdraw my comment. But I heard the member say that there is not always something at the end of the line, that when someone writes a hate speech, hello, that there is not always a victim at the end of the day. But that's not necessarily the case. Just because someone writes something, and there's not someone who's saying, yes, that hurt me, that it didn't hurt them. No, we never know what the effect that written things can have on each person. At the Canadian Human Rights Tribunal, we saw a number of cases based on Section 13 of the Canadian Human Rights Act, and this includes numerous cases concerning white supremacy, Holocaust denial, and other forms of anti-Semitism. The Conservatives' argument under Section 13 of the Canadian Human Rights Act is as follows. Section 13 undermines our rights to freedom of expression in the Rights and Freedoms Charter. They also say that Canadians are already protected against hate speech under Section 319.2 of the Criminal Code. On these two items, Madam Speaker, Their total devotion to their ideology has resulted in amnesia and ignorance on the part of this government.
Let us be clear and honest here in this chamber. Section 13 of the Canadian Human Rights Act does not go against freedom of expression as protected under the Canadian Charter. How can I know that? Well, in 1990, the Supreme Court of Canada in Canada, the Canadian Human Rights Commission versus Taylor, indicated that this, and I feel concerned when the federal government chooses to completely ignore Supreme Court rulings. The second argument by the government is that the criminal code already protects Canadians against hate speech, but they aren't taking into account the important differences between Criminal Code Section 319(2) and Section 13 of the Canadian Human Rights Act. But these differences are important. I need to educate my colleagues across the floor on some of these differences. First of all, the complaints procedure is different. The Human Rights Act enables individuals to make complaints. If the Commission decides that the complaint is important, then it will go to a tribunal. Under the Criminal Code, criminal proceedings will only take place with the consent of the Minister of Justice. Victims of hate crimes should not have to wait until Crown prosecutors look at the case and the Minister of Justice has given the green light. Secondly, the standard of evidence. The Canadian Human Rights Act creates a standard for evidence, whereas a criminal case will require proof of guilt beyond any reasonable doubt. A case before the Rights Tribunal requires basic evidence and the balance of probabilities. As we know, O.J. Simpson was acquitted in a criminal case because the prosecution was unable to prove beyond any reasonable doubt that he had committed the murder, but in the civil case he was found guilty. The complaints procedure and the standard of proof required is different, therefore, between these two sections. And the Canadian Human Rights Commission has indicated that these are complementary and they do not compete. The most important thing is that we need to live in a free society, a society that is free of hate crimes and intolerance. The victims of hate crimes and acts of hate should not need the authorization of the minister, who is partisan, to go forward. It is not always easy to prove guilt beyond any reasonable doubt. When will the Conservatives in this country realize that hate crimes are real and the Minister of Justice should not be able to decide which ones are real and which are not? I would therefore encourage my colleagues to vote against this bill.
Resuming debate, the honourable member for Edmonton St. Albert, and I should say ahead of time I will have to interrupt him at 7:30.
Thank you, Madam Speaker, and it's really an honour and a pleasure for me to rise and speak in favour of Bill C-304, an act to amend the Human Rights Code. Madam Speaker, certainly freedom of speech is a fundamental right that's enjoyed in all free and democratic societies. And I've listened very carefully to the two members, or now the three members opposite, who have expressed concern about my friend's bill, the sponsor from Westlock St. Paul. And parliamentarians, as you know, Madam Speaker, enjoy unfettered freedom of speech. In fact, Parliament is derived, as you know, from the French word parler, meaning to speak. And in this chamber and in its committees, we parliamentarians and any witnesses who appear before those committees have unfettered freedom of speech. And it seems to me somewhat hypocritical that we would not offer to society, to people who write, and with respect to blogs and websites and the internet, which falls under federal regulation, the same rights and privileges that we here enjoy in the Parliament of Canada. Absolutely. And to my friend from from Mount Royal, who I have a great deal of respect for, who talked that there are limits to freedom of speech. He is correct. There are limits to freedom of speech. But, Madam Speaker, no doubt you are aware that there are already workable remedies and workable limits with respect to freedom of speech. There are laws against perjury. There are the torts of libel and slander. And of course, and most importantly and most germane to this debate, there is Section 318 to 320 of the Criminal Code. And those are real hate speech protections, Madam Speaker. And there must be a distinction drawn between hate speech and hurt speech, or the so-called counterfeit right of hurt feelings. One does not have a right against having their feelings hurt. I'm sorry, that is not a right that exists in common law. It's not a right that exists in free and democratic societies. The criminal code sanctions regarding free speech, as found in Section 318 to 320, require something more than hurt feelings. They require real and actual hatred. If you advocate genocide, if you advocate destruction of a group's property, if you advocate harm or damage to the person of that individual or group, then you have fallen offside the hate provisions of the criminal code. And I would submit, Madam Speaker, rightfully so. But that is something quite different than the so-called freedom not to be offended, or what my friend refers to as hurt speech. Free speech, if it is to exist, cannot be subject to some bureaucracy. There is no such thing as government-regulated free speech. Either there is free speech or there isn't. And, Madam Speaker, it is the very offensive speech that requires legal protection. This debate probably would not be occurring if there weren't situations where individuals who had said things that were truly politically correct, offensive and sometimes abhorrently so, but individuals have attempted to avail themselves to the Charter-protected rights in Section 2B of freedom of expression. But I would submit to you, Madam Speaker, and to all members of the House, that it is that very offensive speech that requires protection. Because everything in life, everything that is provocative, is controversial. If we're to get into an intelligent debate about religion, about Christianity versus Islamicism, or abortion, or gay rights, or even climate change, it's impossible, Madam Speaker, to have a thorough and meaningful debate without running the risk of offending somebody somewhere along that process. So a free society requires freedom of speech so that we can have a fluid marketplace of ideas, so that we can have give and take and exchange. And some of the ideas in that marketplace of ideas won't be popular, and they won't be politically correct. But they are important to further the debate, and society has actually moved forward over time because of freedom of speech. Some things that were politically incorrect in their time, for example, hundreds of years ago when Galileo opined that the world was round, I mean, that was thought of as heresy at the time. But he said it, and people debated it, and they argued it, and eventually they proved it. So it is because of the very freedom of speech that we're fighting for today by repealing Section 13 of the Human Rights Code that society can advance itself with respect to enlightenment and with respect to determining truths that may not appear truth at the present time. So the very Human Rights Commission that...
Order, please. The honourable member will have about 5 minutes when this bill returns on the order paper. Regret to interrupt him. La période de...
The time allotted for private members' business has now expired.